Hey folks, you know that busting myths is something that is very near and dear to my heart. In fact, misinformation that is out there has resulted in so many people who would otherwise be able to qualify for a particular immigration classification are denied that opportunity because they believe some myth that they read in a immigration forum or heard during a lunch or a social gathering. And it is really, really important for everyone to get the proper advice and correct and accurate facts in making their decision. One really, really frustrating myth that I've seen over and over and over again is that folks feel that they need to have their entire case ready and prepared before they approach an immigration attorney in seeking to have their case filed. This is a terrible myth that is causing so many problems because it is much better for you to seek out help and guidance really much earlier in the process and then build your case with proper guidance and determination, whether you are filing a self-petition National Interest Waiver or a self-petition EB-1A, if you're seeking a L-1A visa or an EB-1B, regardless of the classification that you are seeking in the complex world of employment-based immigration, it is much, much better, objectively and accurately speaking, that you have received guidance very early in the process. In fact, what I like to do is I like to work with people who are in a class where you can be approved. You don't necessarily have to already be approved to have your case taken up by our firm. In fact, oftentimes one of the most common questions I receive from individuals who are seeking guidance in their EB-1A petition is, do I qualify for EB-1A? And the question actually is not really accurate because perhaps you don't qualify today, but you will qualify tomorrow. Your documentation is what will determine whether or not you qualify. The adjudicator is going to base their decision regarding your case upon the four corners of the papers that you provide them. So what those documents relay or explain to the adjudicating officer should be based upon a very strategic plan that is made early in the process. We like to start to develop strategy, determine that strategy directly one-on-one with our clients, and then execute that strategy. In executing that strategy, we are going to make sure that our petition is going to be built with purpose and benefit you to the absolute maximum. So those of you who are seeking to immigrate to the US, or you're already in the US and are seeking a higher level classification of your employment-based approval, then what you need to do is you need to work with a very knowledgeable source early on in your process to build yourself up to EB-1A, because not everyone will be in a situation where they are already well prepared with perfect documentation to just hand off to an attorney who will then submit it on their behalf. In fact, I think that that is a failed strategy. And when you actually work with someone to build yourself up, it will absolutely give you the optimal opportunity to gain approval, whether it's EB-1A, National Interest Waiver, L-1A, or any other immigration or non-immigration category.